Well, David Nelken, nice to have the opportunity to interview you. I would start by asking you how you came in contact with the sociology of law and what it has meant for you in your academic career.
Well, thank you for inviting me to have this conversation with you. I started doing sociology of law without realizing that that was what I was doing. I was following a doctorate in criminology in the Cambridge Institute of Criminology, and had got interested in a law which was supposed to be controlling powerful landlords and their behaviour against their tenants. And in following up this interest, I therefore became interested in how laws are made and what effects they have, and why sometimes the effects are very different from what is said about the
That was in a British context?
This was in studying the English Rent Acts in my PhD in Cambridge. And so I didn't realise this was sociology of law. For me, this was a step in criminology beyond the question that had become boring by the 60s, though it's never boring to the ordinary people, but to the criminologists, the question of why people commit crime had become boring, and this question had been substituted by why are certain things turned into crimes and treated as crimes, and other things people get away with. So the process of making criminal legislation was part of criminology, but of course, we would say, is at least as much sociology of law, sociology of legislation. And my first job in Edinburgh University, the law faculty, which was in sociology of law, came up like this, that I was interviewed both for a job in criminology and a job in sociology of law, eventually given the one in sociology of law. But I didn't know anything about sociology as a subject to teach or to study, because in England at that time there were almost no sociologists of law. I think that my post in Edinburgh, which was officially lecturer in sociology of law in 1976, was the second or third post of that type. And before going to the interview, I went to the library in the Institute of Criminology and found a book about sociology of law, an American book, and copied out the contents page. And when, at the stage of the interview, they said, "And what would you teach if we gave you the job?" I read out from under the desk the contents of this book, and they were apparently very, very taken aback. "Well, that you can't do all that, you know." But it was enough to convince them that I knew what sociology law was. And at that point, once I had the job, I had to learn what it was. Reading some incredibly difficult books at that time, because I had very Marxist colleagues, so I had to read Renner and Pashukanis and very, very difficult books in order to learn, having been an empirical criminologist more or less, what was required for the more theoretical inquiry that sociology of law is. And I think, in answer to the second part of your question, what doing sociology of law has given me, as compared to my earlier training in history, law and criminology, it's given me this openness to theorizing about social order and sociology in general, beyond just the questions of deviance, which is the special task of criminology. Criminology at its best is also open to these other things, but often criminology is more narrow. Sociology of law can't afford to be narrow, because the laws it deals with cover every aspect of human life, and because it is also about society and how law relates to society, and therefore all the sociological questions that are relevant arise with that. So yeah, I'm very glad that I ended up as a sociologist of law and not officially as a criminologist, though I've tried to ride both horses ever since.
Do you think that law can learn from social science?
I think it can learn from social science, but the risk is of it turning into a social science. If law is created in sociology's image, for example, it might turn law into a much more technocratic subject than it is best to be, if looked at from a different point of view, a humanistic point of view or a religious point of view. If you think about law as being like religion or being like humanities, being like study of literature, you'd come to a different approach to what it is good for. The sociologist assumes it's a sort of technique. Doesn't have to, but often she does, in the sense that you look at whether law is actually performing well? Is it achieving what it's setting out to do, what the politicians tell us it's supposed to do? It's very tempting to assume that that is such an obvious question, is law working, that the sociologist has almost the monopoly on giving the answer. But if the question of what law should be doing, what working means, is the issue, and whether law is a technique or something other than technique, sociology can begin to answer in terms of its own sociology of ritual, of symbols, that there are. Sociology has before, in other areas, also had to examine areas of life which are not so means-end oriented. But it's my impression, certainly in the period that I was doing sociology in the 70s and 80s, that sociology law took for granted that the very success it had in showing that lawyers didn't really know much about the effects of law, and only they could show the effects of law, was leading it to turn law, not just to understand law, but to turn law into an instrumental form of policy making, which is only part of law, not all of law. And laws are rather special sort of policy making, with certain sort of constraints, and it's as much about communities telling their histories to themselves about what they really believe in, what they really want to have, as right and wrong, and aspects, therefore, which sociology can try and grasp, but again, subject to the limits of what the sociologists can do as compared to these other disciplines. So my conclusion in that exercise, if you like, sociology law being, as I've said, a part of sociology, was that in the end, its contribution wasn't the rather too easy one of saying, oh, law's got this wrong sociologically. The lawyers don't understand, the judge hasn't understood, the legislator hasn't got it right. Because you could equally say the law's got it wrong psychologically or economically or in all sorts of other ways, and why should law choose which of these disciplines it should be led by? And if it should be led by them, then why not hand over to these other disciplines? So why leave a space for law? So the job of sociology isn't to replace law or to keep calling it to account for its being unsociological. Its job is rather to seek, or in addition, to understand, as far as it can, in what way is it justifiable in legal terms to be unsociological? Are there aspects of law which require law to be uninterested in what's going on? And a simple example to understand what we mean is when in the common law system you don't tell the members of the jury what the criminal has done in the past in terms of previous offences, what the person being tried has done before. That makes no sense if you're a policy maker, because one of the best guides for the criminologist to whether a person commits a crime is whether they've done it in the past, whether they're recidivists. Keeping that information from the jury has nothing to do with effectiveness. It has to do with all the other principles that lie behind why we have trials. It's not designed to make sure we get the right person. It is designed almost to make us not necessarily get the right person, but to respect other principles. So learning more about under what conditions legal institutions, lawmaking, isn't just the same thing as policy making in the absence of law, is a way to grasp the significance of legality for the sociologists of law. And if the sociologist of law doesn't grasp legality, then they're not doing their very specific task as a sociologist of law rather than as a general sociologist. Sociology, when it comes to law, of course, a lot of law, a lot of the time, is concerned with effects, and therefore the social scientist is very good at that. Particularly, that was the main contribution being made in the 70s. But it's not just about that. So that sociology, which always will remain sociology, ought to be as interested in ritual, symbolism, tradition, these other aspects which are important to law, which were a bit neglected in the 70s and the 80s. They're not the things that come to people's mind when you think about what does the sociology of law do. What the sociology of law does is make that law against environmental pollution work better. I'm not saying they shouldn't, but it is a reductive approach to what sociology can do, and even more a reductive approach to what law is.
I think you have an important point there. And do you think that lawyers and legal science are good at articulating their own specific value?
That's a very good question, because that brings us from the external to the internal. Yeah. So the social scientist who tries to grasp the internal point of view, always in a sociological way, comes up against the problem as you do every time, whether you're trying to understand religious practice or in anthropology, other cultures' ideas. Are the members who are carrying out the practice always those best qualified to know what it is they're actually doing? Or do we still need, in some sense, an external discipline to give us a better version of what they really are doing, what really the meaning of their actions? And the answer is, of course, that you can't do without taking seriously what people are trying to do, but it isn't the end of the story. Certainly, you do, as taking a broader view, speaking to many people and so on, you learn much more about what judges are doing, what prosecutors are doing, than they themselves may know. For example, they very rarely know what somebody's doing in the court down the road. You, the outsider, do. So when you describe their perception of what they're doing, you are entitled to say, and they don't understand exactly what they're doing, because somebody else down the road doing something different shows that what they assume is a fix is not really fixed at all, and so on. So yes, you interpret, you must do an interpretation of what lawyers are trying to do, but you don't have to be tied into that if you can see further than them.
Would you agree that law and economics, for instance, they use an explanatory empirical approach in order to give normative advices, how the tort law should be designed, or contract law, etc.?
They do.
That's an interesting aspect of
very
what you're bringing up.
It's not clear whether law and economics has been so successful because, in a way, it lays its cards out more clearly that economics is different from law, we'll give you something extra you can use, or whether it's been more successful because, in a way, it's more similar to law, that it starts with assumptions, not normative assumptions, explanatory assumptions, but this is what we're going to assume, and is much less interested in the nuances of description and explaining variability than sociology. So therefore it's a more universal type of subject. Law as a universal subject, economics as a universal subject, can work together with a sort of rationalizing how the world is under certain conditions, what is likely to happen.
But
so
by rationalizing, they come up end up with a normative solutions or normative recommendations, how to cope with a certain problem.
If you would want to achieve this, this is what you should do. A lot of the time, at least in the Posner school, they assume this is what at least the common law is trying to do, be more efficient, and since economics deals with an efficiency, that's true.
How about the gap problem? That was a problem at an early stage in sociology of law and also in your writing, as I understand.
The gap problem will always be, I think, the starting point for most people who come to study law from a social science point of view. Because when you see empirically, by doing research, what actually happens with law and discover that it's not exactly what the law says is supposed to happen, then this is great news. The problem for the development of the discipline of sociology law is that this great news stops being news when it's been discovered hundreds of times. The mere fact that legislation or judicial decisions or administrative rules are not kept perfectly in practice. Because at the time that I was now working in the field in the middle 70s, again, the Americans, Rick Abel and others, were saying sociology of law has become very boring and repetitive. Each time somebody takes a legal decision by a judge, a legislative intervention, an administrative rule, goes out into the field and sees what actually happens, the law in action, is not the same. This is big news if you're a lawyer, maybe even big news if you're a citizen. So therefore there's always an audience for this. It's shocking to find that law is a job like other jobs and people cut corners, that law takes place in organizations, and like all organizations, the informal is as important as the formal, also to make anything work properly, not just to get around things. But the message had been made, had been given again and again. What was the point, asked Richard Abel, to keep repeating the same discovery that there is a gap between the law in the books and the law in action? And therefore my interest was to see how to make this more theoretically useful. In my PhD book, I wrote about the next question should be, how is the gap managed? If there is a gap, how do the people who apply the law manage to conceal that gap? When is it a problem for them? And how is it, therefore, we don't get to know about it? That was one empirical issue that then you could study in different settings. At the theoretical level, the question became, was there a better starting point for sociology law than this starting point, which goes back to Roscoe Pound and the legal realists, which assumes that law is so important in explaining society that if there's a gap, if there's a difference between what law says and what happens, this must be explained. That's a starting point which is a legal starting point. It isn't a social science starting point. Social science starting point, Roscoe Pound was a lawyer, Dean of Harvard. A social science starting point I found was much more in the work of Egon Ehrlich, who, even though he too was a lawyer and a legal historian, writing just before Pound, had the sociological imagination that Pound seemed to lack. Pound was very interested in law reform. Ehrlich was very interested in explaining why normative patterns are the form they take, and what he called them was living law. And so the study of living law seemed to me more theoretically fruitful, bringing together the study of norms and sociology of norms, which is what you work on, with the interest in law and patterns of law, patterns of norm and their relationship, where norms come from, whether or not they need to be turned into law or not, seemed to me a much more fruitful question than why the legal rules that are made are not always in practice the way they seem on the books. They're used in different ways, they're deflected, people get round them. It's not that those things aren't terribly important questions, but they're more practical questions.
This gap problem, it's related to the distinction between law in books and law in action, as we know. Law in action was a concept put forward by the famous American legal scholar Roscoe Pound. How would you describe this distinction between law in books and law in action with Eugene Ehrlich's concept of living law? Are there similarities and differences?
Yes, thank you for that question. This is something that I wrote about in 1984, and emphasizing that although there's an overlap between talking about the law in action, what the law actually does, and living law, what Ehrlich said, the law that really matters in society, rather than what the court in Vienna has put in legal codes, there's also very important differences. One of the most important differences is this, that the law in action is just what happens rather than what should happen. Police not following all the rules of legal procedure in interviewing a witness or the defendant because they want to get a good result. That's law in action. But living law is not just what actually happens. It's about what ought to happen. But what ought to happen, not starting in terms of lawyers' decisions or legislation, but what ought to happen in terms of the norms, the ways of doing things accepted and built up over time in different groups and associations. So even living law can then be broken up into living law in the books, if there were books, if you like, imagining in people's heads, and living law in practice, living law in action. Because all norms don't necessarily get put into practice. Living law, and that's why it's such a fertile category, living law directs our attention to norms. Law in action directs our attention to practice.
I would like to turn to another subject, legal culture. I know that is at your heart, so to say, in sociology of law. Would you try to start with a definition of this hard concept to define, but give us an understanding of the concept?
Legal culture is a concept that in sociology of law was introduced by Lawrence Friedman, and he took it to mean why people turn to law, why they bring pressure to have social problems solved in a legal way rather than in some other way. And he was interested in the way this pressure changes over time. You have in America the development of what he called total justice, the idea that every problem had to have a legal solution with all the consequent defensive lawyering that goes on as a result. My own interest in legal culture, on the other hand, is a comparative one. It arose when I changed country and saw a very different way of using and avoiding law in Italy compared to Great Britain, where I'd grown up. So for me, legal culture includes everything that could be potentially relevant in explaining why law has the form it has, from the number of judges or lawyers to the way they behave in using law, or the public behaves in using law, to mentalities, ideas and values that lie behind why certain things are considered to be right or wrong and put into law.
It's a question both of an external and an internal perspective, isn't it?
Friedman stresses the external and the internal perspective because since his approach to legal culture is what makes law move, and for him it's the society's pressures, it is the development of new technology. He says before there were cars, there was no laws about car accidents. Once there are cars, that's the major part of the law of negligence. So clearly law, and this is his point as against the law scholars, law is not separate from society. It responds to, and should respond to, and needs to respond to society's pressures, but we can study when and how and why this takes place. That's the importance of external and internal for Friedman. For me, external and internal has a different importance. In comparing legal cultures, you find that in some societies, the external is considered to be what ought to affect the law. It's right that the public should be able to say, to some extent, what happens in law. And sometimes they're given roles within law to do that, as lay judges or as jurors and so on. In other societies, particularly continental European societies, law is thought to be at its most law-like when it keeps the public away, when it's not shaped by public sentiment, but is able to show the public what ought to be done. When you are facing such differences in patterns of law, the desire of how to explain where they come from, what they mean, and how to characterize them, is my interest in legal culture is much more what's called the anthropological sense of the term, understanding how a unit hangs together. In what way, as I mentioned, does the length of Italy's court processes connect to the way politics functions, economics functions, society functions? Short answer, if society depends very much on group connections and depending on getting on with other people, then giving an individual a lot of rights as an individual, irrespective of how much they take trouble to fit in with the group, is a threat to social order. Law becomes a threat to social order. And therefore, the time it takes for law to give you your rights is not just a measure of inefficient courts, which it's too easy to say, or denial of justice, as the Court of Human Rights says, which may be true, but doesn't give the sociological point. In sociological terms, it's a measure of how much this society is one that works through the everyday creation of social order in systems of interdependence between people. And therefore, too much individualism, too much defense of individual rights would threaten that. And therefore, rather than being a social problem, it begins to be an answer. You begin to see what it's about. Now, that holistic approach to legal culture, therefore, requires a definition where legal culture includes everything. It includes how many judges you have, how they're appointed, how they're disciplined. It includes what they do, what people do with law, what the legal officials do with law, and it includes mentalities, ideals, and values about law. Explain the fact that there are differences without using an out-of-date and no longer convincing idea of separate cultures.
Mm-hmm. You use it both as a kind of analytical tool to understand certain aspects of the legal system, and as an empirical fact, so to say. You have different legal cultures in Strasbourg, Italy, Denmark.
Yes, the point is well taken, because there is the most easy answer, maybe a bit cheating answer, to the problem I've raised here of the fact that cultures are no longer separate, and also an answer to cultural criticism that if you say culture explains, it's too easy to become tautological. Why do the Japanese do what they do? Because they're Japanese. Why is Italian legal culture like it is? Because it's Italian. Why are legal delays long in Italy? Because that's legal culture. Yes, but the definition of legal culture includes the fact that court cases take a long time, so you're explaining something by itself, tautological. One way of getting out of all those problems is to say, I do not use legal culture analytically to explain. I merely use legal culture as the name of what I'm explaining. To explain it, I need to refer to economics, politics, culture in general. And what I'm trying to do is to explain Italian legal culture. I'm not saying that legal culture is the explanation. So one way of avoiding the falling down the holes is to just say legal culture is not something that explains, but it's something to be explained. But I think one can do better than that. I think one can also, and in my writings I've tried to show that there are times where legal culture is also an explanation and not only something to be explained.
I would also like you to comment on the concepts of legal autonomy versus autopoiesis, and especially if you would like to explain for us more about the concept of autopoiesis. What does that mean? Is it a new paradigm, etc.?
Yes, thank you. I think that legal autonomy for those trained in the Anglo-American tradition is relatively simple to grasp. It has to do with the extent to which law is separate from politics and economics. And it has as much to do with an ideal as with practice, that is, the rule of law. The rule of law requires, in some sense, that law is not just what the powerful want. That's why we have courts and legislatures and ways of producing these common norms that we're supposed to live by, called law, which have to follow certain procedures. So that separation, that autonomy, or as they would prefer to say, relative autonomy, some extent of autonomy, is a deep part of what we want from law. Legal autopoiesis, on the other hand, comes out of the thinking of one of the major European sociologists, Niklas Luhmann. It's not an ideal, it's more a description of the stage that law has reached in this period of time historically. That having become positivized, that is, laid down as separate rules which are not similar anymore to the ordinary ethical or customs or other norms in the wider society, it then took a further step of differentiation, of being separated out from other rules in society, when society became a system of systems, when society was divided into political, economic, scientific, legal subsystems, to allow for the complexity that Luhmann says modern society needs and has produced. Complexity depends on differentiation of each subsystem doing its own thing and collaborating. Against that background, legal autopoiesis is the way he describes the fact that when the courts and even legislatures produce law, law relates and communicates with law rather than with these other subsystems. That if politics is about power and economics is about prices, law is not about those things. Law cannot, should not communicate in those terms. It communicates in its own terms. It has implications, it has consequences for these other spheres, these other subsystems, but it reproduces itself. Autopoiesis means reproducing itself in its own terms. Law is, and should be, according to the ideas of rule of law, separate and separable from politics. And you can see there is an overlap, just as there was an overlap with Pound and Ehrlich between law and action and living law. That Luhmann is very much stressing autonomy in the sense of saying that there are separate subsystems of society that refer to themselves and need to if society is to develop a sufficient level of complexity. So in his first stage of thinking, because Luhmann has been through a series of stages of thinking, he went through a series of stages of thinking, the emphasis was if society is a system of systems and the political system is about power, the economic system is about prices, scientific system is about truth, and law is about legal, illegal, or lawful, not lawful. These subsystems are, if you like, masters in their own universe because this allows for a level of complexity as compared to simpler societies where politics, economics, and so on are not really differentiated. It's about the differentiation of society. Durkheim's idea of division of labour taken to a next step, not about separate different types of jobs, but separate types of subsystems. And therefore, law is separate from politics and economics by definition, that it's part of a separate subsystem, dealing with, starting from different assumptions and dealing with different tasks. But legal autonomy in the Anglo-American approach comes out of the idea that law should be above or beyond politics. And since, of course, it often isn't, or difficult that it could be, whole disciplines like political science get a lot of their kicks out of showing each time, no, democratic judges decide differently from Republican judges, so what happens to the rule of law? What happens to legal autonomy? So legal autonomy and legal autopoiesis have this in common about law as separate or not. And it's crucial for sociology of law, because sociology of law's starting point, of course, is precisely about the non-separation of law. Unlike the lawyer's way of looking at things, in which there's legal doctrine, law, if you like, is its own separate sense of taught tradition, the sociology of law is saying, no, law is part of society. So it's interesting that even within sociology of law, whose starting point is law is part of society, shaped by society and shapes society, there is the need to say, but one of the aspects of law that even the sociologists must understand is, unlike some other things which are part of society, law is supposed to be, in some sense, separate from society. Only in that way can it have the legitimation, the respect to actually do what it has to do within society. So it's quite a complex idea. Law, in order to be law, has to be considered to be separate from society, certainly from political influence and economic influence, in order then for it to actually shape society. And legal autopoiesis, unlike legal autonomy, is less concerned with the idealistic aspect of this, that it's right that it should be separate. It's more concerned with taking further the idea of differentiation that we've mentioned. In what way does law relate to law and not relate to other subsystems? And with the next step of Luhmann's thinking when he got to autopoiesis, borrowing a biological idea about how seeing is a process which as much constructs what is seen as seeing something which is out there, the notion of law relating to law takes strength. It becomes a question of law communicates with law, even when it seems to be talking about what's outside law, the context, as with the eye that is seeing only what the eye can see, going back to Kant's ideas about time and space being categories of the mind, if you like, if you want to bring in a predecessor. Similarly, law can only communicate with law. When it uses economic ideas or sociological ideas, says Teubner, Luhmann's follower, it's using them in a legal way, which have lost the sense that they would have used in other disciplines, in sociology, for example, or we mustn't assume they correspond to what actually is out there. They're law's way of knowing the world. So law has a way of knowing the world, and autopoiesis is the way that law reproduces itself by being open and closed at the same time. It's open to the world, but it's closed in the sense that in order to remain law, a bit like I was talking about how sociology reproduces itself earlier in our conversation, law always, everything it touches is law. So it sees the world in terms of law. It communicates with legal categories. Legal autonomy, partly because maybe law in the common law world is a little different from the way in the European world, is much looser about this. It has, since the growth of legal realism, much easier about thinking that actually law is not so separate. And legal autonomy becomes more a question of principle, that it ought to be separate from the wrong things, the things that might influence it to favour inequality, to favour power rather than less powerful. So that I would see legal autonomy as not being the same thing. But many people in the Anglo-American world who first read Luhmann's ideas thought this was a way with lots of extra and unnecessary language to repeat the basic Anglo-American ideal about legal autonomy, which then the sociologist or the political scientist goes in and shows to be, a lot of the time, myth claims which are not true in practice. Legal autopoiesis is not about a claim that will not to be true in practice. It's a theoretical presupposition that assumes that subsystems can only relate in terms of their own assumptions. You cannot question the difference between law and not law in legal terms. because there is no way of getting beyond that. It's a starting point. It's a way of seeing things, seeing the world in terms of law, not law.
EU and the part of law in creation of the European Union in this perspective is that, I mean, it doesn't seem relevant perhaps to talk about autopoiesis and legal autonomy. Is this something quite opposite to?
I'm not sure what you mean by the question. Do you mean that it's so evident that law is part of a political project when you're talking about the European Union?
Which might be a question mark behind, but...
It's a sort of objection that, with respect, also the Anglo-Americans make to Luhmann. If you start with legislation, any legislation, not just the European Union's attempt to create a ever closer unity and diversity, whatever that's supposed to mean, any form of legislation, even domestic legislation, is so obvious the interface between politics, the politicians who, as a result of political conflict and consensus, produce some sort of law, and the form that law has to take to be consistent with previous legislation, to be able to get past constitutional courts and so on, so that legislation is the interface between law and politics, that they would say to Luhmann, what do you mean by legal autopoiesis? They would exactly be saying legal autonomy is something to be shown that exists only in a rather limited sense, not in the sense that law is separate from what else is going on in society. The whole point of sociology law is to show, no, look how politics shaped that particular legislative outcome and how you lawyers need to know that to understand a lot about what actually happens. Seen in those terms, asking the question as you do, how would legal autopoiesis deal with European legislation? The answer can't be it would insist that there's a separation between law and politics. It's difficult for me to speak for autopoietic theorists, but I guess they would still insist that once it becomes law, at the point it becomes law, it is and needs to be no longer working in political terms. It's almost as if the problem of legal autonomy for the Anglo-American, how do we keep law not being political, is solved, like by Zen master. Look, it's solved. It's no longer political. Now law only relates to law. Norms call to norms. Law is open but closed. Open to the legislative politics, open to ideas that come from social science, but closed in the sense that as it reproduces itself in an autopoietic way, in a self-closing way, it necessarily changes the meaning of these terms, the significance of politics, to relate to what law as a subsystem does. Example, for Luhmann in his early work, even before autopoiesis, law is the place where things that politicians can't solve in other ways often put things, because by kicking it into law, as it were, you sometimes can have the best of both worlds. It looks as if it's solved, but it's not solved. So that's one approach to what the role of politics within law is, as compared to politics outside of law. Politics, when law is doing political jobs, it's doing them in legal ways. One political science commentator about legislation talked about words that succeed, policies that fail. Why that's happening? Because that may be, from a Luhmannian point of view, words that succeed. That is one of law's job, to deal with the impossible things.
Could you think that it's some kind of division of labor on different levels here, that the processes in EU, in the Commission, would be a kind of more similar to a legislative process, and the autopoiesis way of working for law comes into play on the different domestic arenas when these directives, for instance, are going to be implemented in the different member states, if you understand that.
You're asking me to say what an autopoietic theorist would say, and I'm not an autopoietic theorist, but I would say this, that often autopoietic theorists seem to be better at defense than attack, better at saying we cannot predict what's going to happen than in telling what would happen. And therefore, their contribution would be that at any level, both at the domestic level, but also at the European Union level, when law tries to achieve policy outcomes, the things that I was talking about before, we should be careful that law shouldn't become too much just like policy, too technocratic, reducing everything to means and ends. Their answer would be, actually, if insofar as it's law that's doing it, it won't really be like that anyway. Why? Because so much of the way law works institutionally and cognitively, it doesn't allow for this ability to produce direct results as the policymaker would. It's very much more normative. To take one example, Luhmann's wonderful definition of law is something that refuses to learn. Refuses to learn? It's very opposite of policy making. But yes, refuses to learn because oughts, things which ought to be, remain oughts, things that ought to be, even if evidence contradicts them. Promises do not cease to be valid because many people, much of the time, are breaking them. So there you see that law is about not learning, and that's very telling, if you like. So yes, we're all legislators, politicians, the man in the street, asking law to deal with a problem. There's a problem, there ought to be a law. When they say there ought to be a law, they mean solve it. But this highly sophisticated, leading sociologist, Luhmann, applying himself to law, suddenly sees in law the very opposite. So that's what's interesting, always has been interesting to me about the autopoiesis approach. It came into my line of vision because of this question that I mentioned before. Where do you draw the line between saying law is just sort of a pale and rather not very wised up form of social science that we must help, poor thing, to better do its job? And where do we say, no, law is not as such a social science. It is a particular human activity which social science offers one view, only one view, which is illuminating, and which sometimes should lead us to changing what law does, but not to the extent of transforming law into being a form of social science guided policy making, because it's more and less than that. More and less than that.
Would you say that there are other paradigms or theoretical traditions in sociology of law, or is sociology of law recognized by dealing with certain problems in society? If you understand me, I mean, if you.
Well, I think that Foucault is extremely relevant even today, because the thing I'm most interested in at the moment has to do with global indicators. The way in which, as the state gives way to transnational agencies, organizations and so on, because the problems are transnational that we have to deal with now, the way of testing what progress is being made in handling these various forms of social problems is what is called in the literature global indicators, indicators of what is actually happening, measurements, placing, as with Transparency International, countries in order about how transparent, how free of corruption they are. But the same applies across everything from how to reduce teenage pregnancy or malaria, more technical or sort of technical subjects, to how to stop bankruptcies. Every area of law and in relation to social problems, I work on human trafficking, seems to be that there are indicators of how people are doing. America applies countries into 3 categories about how much effort they're making to stop human trafficking. And then it insists that those countries which are not doing enough will not have the benefits of trade or aid or whatever. So they're very strict sanctions. More normally, the United Nations or other international organizations have these lists. They don't have as much sanctions as the United States, but this sense of being considered to be on the right side or on the wrong side of these various indicators, or high or low, does have some influence on what states do. Now, in studying this process, the question arises, the yardstick, the criterion being used to decide what is or is not proper behavior in relation to these various matters, moral, legal, practical, political matters, often to do with human rights, that are being monitored, surveyed, measured, encouraged. The question of what norms there are often overlaps with what is normal, normative and normal. And therefore we go back to Foucault's idea that the normalizing, in some of my work on legal delay, even before I got interested in global indicators, I was fascinated to discover that the European Court of Human Rights, right, going back to Italy, how long cases take, has to decide, in order to give relief to the citizens that bring the case against the states, to that European Court of Human Rights, the states who are the signatories to the Convention of Human Rights, has to decide when is it too long. Well, there's no legal definition of when something is too long. And you might think, well, it must depend country to country. Oh no, because global definitions have to make universal solutions. If it's too long for everybody. Never mind, Denmark, cases take 55 days, and Italy takes 10 years. How do they discover? How do they decide? They make a sort of average. If it takes more than, they never define it, but in practice, if it takes more than 3 or 4 years, then there's a good chance you're going to get some sort of compensation, depending on other circumstances of the case. Now that is interesting because it's solving the problem what the norm should be about how long a court case should be by looking at what is normal, what is the average. And then this fact that Italy is regularly, convicted is the wrong word, but forced to pay damages, or asked to pay damages to people for the time they've had to wait for court cases. And together with Turkey for its behaviour in Cyprus or against the Kurds is the country most in breach of the European Convention. The question arises, well, is torturing a Kurd in prison because you think he's a rebel the same thing as taking longer on average than other countries take for their court cases? And what about countries that take very little? Why are they never taken to court? Why isn't Denmark in court for only taking 55 days? If, as Italians say, that's not law. We need long. So the issues of normal and norms, the way in which the new global order, transnational legal order, a new one-day global state, is being formed in our time, in our generation, as all these various, normally through social problems or coordination problems that then are solved by agencies, international or intergovernmental, which create these forms of monitoring, which then have to have, particularly when money's put in to help countries, you have to audit, so you have to have some measure of what they've achieved. By these indicators, this is, to me, one of the most exciting things going on in the sociology of law, and the ideas of Foucault continue to be very relevant for this.
How about the new technology, information technology? How does that affect law, you think, in a short-term perspective and a long-term perspective? Do you have any idea about that?
It's an enormous area. There's so many ways in which law and the changes in communication, that's what we're talking about, overlap and intersect. One way that I was interested in when I wrote a retrospective of the effects of Ehrlich's ideas, his legacies, was to ask whether the way the norms develop in cyberspace is something that can be illuminated using Ehrlich's ideas. And that's pretty important. I mean, a book that I published for a friend of mine who died young, unfortunately, called Hate on the Net, was about the incredibly terrible things that you find the internet being used for, and the lack of any sort of control of them, and the dangers, of course, of trying to control them, because then you'd be led towards censorship and the use of these media, as we've seen recently in the Arab Spring, for example, as alternatives to official media, in order to communicate what is happening and to denounce what is happening and to give information what's happening. This would be lost as well. So it's a whole new area that both needs regulation but needs not to be over-regulated. And as always, the sociologists of law's first question should be, unlike the lawyers, not how can I better regulate this, but how can I better understand how this part of social life is already generating forms of self-regulation, which is what we mean by norms. And what sort of norms are growing up? Where are the difficulties? Where do the areas seem to be where they can't easily seem to develop, that we need to supplement? Because so often the sociologist of law finds that legal reforms done without a background in sociology of law either legislate what already exists informally, but it changes if it's made legal, sometimes for the worst, making it too rigorous, rigid, or has missed the real point of what's going on. and you need to, and may therefore be threatening reasonably successful forms of self-governing order. So one needs to know much more about how these transnational forms of communication and collaboration are working. Of course, when you come on to questions, as I know you're interested in, of property rights and so on, and the question arises whether property rights can continue to be what they once were. I've just written a revised version of the chapter on white-collar crime, because I also do criminology for the Oxford Handbook of Criminology, and business crime, white-collar crime, and reflecting on what went on with the way the banks behaved up until 2008 and the crash. I entitled that section Theft as Property, because the idea that you can leverage up the deposits you have without telling the people who put those deposits, this is what you're going to do with the money. Up until now, we understood that our money wasn't always in the bank when we wanted to get it, but enough was there when we would need it. But the idea that you multiply it out of all levels and put it on highly risky activities which sooner or later cannot continue at that level, that's almost theft in the sense that you know you're not going to be able to give it back. But as property, that's a new form of property. The system forces you to behave like that, in the sense that if you bank don't do that, the other banks will make bigger profits and you will go to the wall. That's the new way of doing things, with derivatives and swaps and all various means by which you are betting against yourself, whether if it does fail you get insurance. A whole new world develops and property changes its meaning. Well, if property changes its meaning, has been allowed to change its meaning in practice, because we're all poor as a result of what happened there, so maybe we don't want it to happen, but who knows if we can go backwards on these things. If property has changed its meaning there, then on the internet, when it comes to the various things that people are saying are being stolen on the internet, we have to rethink what property means. And in time, people will make their money in different ways, and intellectual property in its various forms will still learn how to make money, as many those big companies on the internet are amongst the biggest earners, but they're earners in a different sort of way. Is the transnational arena just the national arena writ larger, or are there special aspects of it which require new special theories?
With perhaps new forms of social life taking place or emerging I think, for instance, about social media and the implications of Facebook and all these
Sure, that's what I'm talking about, space. The space that is constructed in Facebook is not just not the nation-state space. It's not an international. It's a sense of belonging and being together, which seems to be no respecter of space. But nonetheless, divided off from other communities, it has its boundaries. But its boundaries and its borders are not those we're used to dealing with. So the challenge is all there to establish, because this is normative again, how normatively these boundaries are created, maintained and protected.
Perhaps we can talk, going back to Durkheim, about a kind of new kind of organic solidarity.
Well, I'm interested in the application of Durkheim to these issues that we've been discussing. For example, should we say with Durkheim that when you have, through globalization, more trading and other connections, you could never have that without, at the same time, that presupposing and creating moral, in his sense of moral, normative connections, based not just on shared expectations, but on shared sense of what is right, producing a new sort of moral order. And if you find laws that say human trafficking, will be stopped, or just more excitingly, that sexual tourism, doing the same thing in reverse, going to other countries to take advantage of people there, that locally, domestically, laws are being made against that. And the question arises, why should the country do this? Is it just because it doesn't want its people doing that there, or is it also concerned with what happens in that other country that previously it would never be concerned with? If it's a bit of both, then you have the beginning of a sort of international legal order, in the same way that you once had a national legal order, where, as Durkheim insists, there can never be interconnections between people without them also producing moral things. So the worry that people have, globalization is just about markets, and everything else is left behind, politics is nowhere, morality is nowhere, is perhaps worrying a little bit too much, because so how much Durkheimian organic solidarity at the very level of the whole globe, or in the particular groups you're talking about, Facebook or whatever, is existing or possible to exist, is in part a theoretical question, but also needs a lot of empirical research. Also, so as to try and, if one believes in it, make it more possible rather than less possible.
I think that's a good conclusion of the talk we have had, and thank you very much.
Thank you very much. Thank you too.
Certainly touched upon most of the relevant problems within sociology of law.
Glad.
Thank you.
Thank you very much.